Good evening to all distinguished participants, faculty members, researchers, scholars, industrial professionals, and my dear students. Welcome to day 3 of our 5-day faculty development program on patent filing process in India. It's my immense pleasure to take you through today's practical and highly important session on hands-on drafting of patents and prior art search. Today's program is designed to move beyond the theoretical understanding of patents and focus on the practical skills required to transform an innovative idea into a properly structured patent specification and to evaluate its patentability through systematic prior art searching. The overall objective of today's program is simple but significant. Draft precisely, search smartly, and protect innovatively. Today's session is organized into 5 structured components. We will begin with the structure and the components of a patent specification, proceed to step-by-step patent drafting, understand the concept and importance of prior art, undertake hands-on prior art search using Indian and international databases, and finally analyze prior art from the perspectives of novelty and inventive step. Now we will directly get into the module 1, structure and components of your patent specification. Let us begin with the first module. Your patent specification is not simply a technical description of an invention. It is a carefully structured document that establishes both technical disclosure and the legal scope of protection. The first component is the title of the invention. The title should be very concise, technically accurate, and representative of the subject matter of the invention. Second component is the field of invention. This section identifies the technical domain to which the invention belongs. Third component is said to be background of invention. Here we explain the existing technology, identify the relevant limitations, and establish the technical problem that the invention seeks to address. Fourth component is the object of invention. This explains the specific technical problem that the invention is intended to solve. Next comes the summary of invention. The summary provides a concise explanation of the essential features and overall concept of the invention. The detailed description is one of the most important portions of the specification. It should provide sufficient disclosure to enable a person skilled in the relevant field to understand and work the invention. We then arrive at the claims. Claims are particularly important because they define the legal boundary and the scope of protection being sought. Finally, we have the abstract and drawings which provide a technical summary and visual representation where appropriate. Therefore, every component of a patent specification has a specific purpose. Together, these components create a coherent technical and legal case for protecting the invention. Module number 2, we are going to discuss the process flow of step-by-step patent drafting. Let us move to our next segment, step-by-step patent drafting. Patent drafting should be approached very systematically. The first step is to capture the invention. At this stage, we document the technical problem, the proposed solution, the important technical features, and the working principle of the invention. The second step is to conduct a prior art review. Before investing significant effort in drafting, it is important to understand whether similar technologies or disclosures already exist. The third step is to draft the title and field of invention. The technical domain must be framed accurately and clearly. The fourth step is to write the background and object of the invention. This positions the invention in relation to existing technology and clearly establishes the problem that needs to be addressed. The fifth step is to describe the embodiments. A description should provide adequate technical information so that a person skilled in the art can understand and replicate the invention. The sixth step is to draft the claims. This is the critical stage because the claims define the legal scope of protection sought. The seventh and final step is to finalize the abstract and drawings. These provide a concise representation and visual explanation of the invention. In today's practical component, the participant will work on a sample invention disclosure and develop it progressively into a patent specification and claims with guidance and feedback during the session. Next module, we are going to discuss about Introduction to Prior Art and its importance. Let us now understand one of the most important concepts in patent examination, prior art. Prior art refers to the evidence such as published documents, earlier patents, public use, or any disclosure that existed before the relevant filing date and are relevant to assessing the novelty and inventive step of an invention. The presentation also connects prior art assessment with Section 2 and 13 of the Patents Act 1970. Why this is very important? First, it helps us to assess the novelty. We need to determine whether the invention has already been disclosed in the existing body of knowledge. Second, prior art helps us to determine the inventive step. Even if an invention is not identically disclosed in a single earlier document, we must consider whether the claimed technical features would be obvious to a person skilled in the art. The third thing is prior art searching helps in avoiding potential infringement risk by identifying existing patent rights and technologies. Finally, a well-conducted prior art search can help us to strengthen the patent application by enabling the applicant to prepare a technically and legally robust specification. Therefore, prior art searching should not be considered merely as a formality. It is an important part of the patent strategy. Now we are going to have a practical session on hands-on prior art search. Before that, let us go through the basic introduction features of hands-on prior art search. Then we will move over to the case study description, how to do the prior art search and patent drafting. In the form of case study, we are going to discuss. We now come to the most important practical component of today's program, hands-on prior art search. Objective is to learn how to navigate Indian and international patent databases systematically. Among the Indian resources covered today is Intellectual Property India, the Indian Patent Advanced Search Engine. We will also consider IP India e-Register, which provides information relating to application status and the patent register. Next one is Intellectual Property Organization Patent Journal is another important official resource for published patent applications. For the traditional knowledge related searches, the presentation introduced the traditional knowledge digital library. Moving to international resources, we will examine European Patent Office. We will also consider WIPO patent scope, which provides access to the International Patent Cooperation Treaty applications. Another important source is United States Patent Application and Granted Patents. We will also look at platforms such as Google Patents, which can assist with fast full text and citation linked searching. The purpose of this hands-on exercise is not merely to locate the documents, it is to develop a systematic approach to identifying relevant disclosures, comparing the technical features, examining patent families and citations, and understanding the technological landscape surrounding an invention. Now we shall go through the case study relevant to the current slide. So in this session, we will undertake a practical and hands-on case study on patent drafting and prior art search. The objective is to understand how an engineering or research idea can be systematically transformed into a patent-oriented technical disclosure and subsequently into a preliminary patent claim. Our case study title is Development of an IoT-enabled smart warehouse monitoring system. Let us discuss the background behind. The proposed system is designed to improve inventory visibility, environmental monitoring, energy efficiency, and worker safety. It integrates several technologies including IoT sensors, temperature and humidity monitoring, RFID-based inventory identification, automated alerts, edge computing, cloud-based data storage, energy monitoring, predictive analytics, and a mobile or web dashboard. Let us first understand the problem statement addressed by the invention. The conventional warehouse systems often use separate systems for inventory monitoring and energy management. Such a separation may result in delayed identification of inventory problems, excessive energy consumption, manual inspection, poor coordination between sensors and warehouse equipment, delayed alerts, and limited predictive capability. Therefore, the research team wants to determine whether its specific technical integration and control mechanism contains novel and inventive features that may support patent protection. Let us further understand the proposed invention. Let us examine how the proposed system operates. The basic architecture follows this sequence: RFID tag, RFID reader, followed by that edge controller, sensor data processing unit, decision engine, automated action, cloud dashboard. The system continuously collects inventory identification data, temperature, humidity, power consumption, equipment operating status. The important feature is that the edge controller processes the data locally. When predetermined conditions are detected, the systems can generate an alert, adjust ventilation, activate or deactivate cooling equipment, identify the potentially damaged inventory, and update the inventory database. The key technical contribution proposed in this case study is the adaptive decision mechanism. This mechanism correlates inventory status, environmental conditions, and energy consumption to automatically determine the appropriate warehouse control actions. This is particularly important from a patent drafting perspective because we should focus not merely on listing individual technologies but on identifying the technical relationship and functional interaction between those technologies. So with this problem introduction, now we will move on to the basic hands-on exercise. The first one is prior art search exercise. Let us now move to the first practical activity, prior art searching. Before drafting a patent application, participants must understand what has already been disclosed in the relevant technical field. The first step is to identify the appropriate keywords. The important keywords include smart warehouse, IoT warehouse, warehouse monitoring, RFID inventory monitoring, environmental monitoring, temperature monitoring, humidity monitoring, energy management, edge computing, and combinations of these concepts. The the participants should also experiment with the combination searches such as IoT and warehouse and RFID, smart warehouse and temperature monitoring, RFID and environmental monitoring, warehouse and edge computing, and the warehouse and automated control. The purpose of the search is not simply to locate documents containing similar words. The real objective is to determine whether earlier patent documents disclose the technical features and relationships of the proposed invention. For this exercise, the participants may use patent databases such as Google Patents, WIPO Patent Scope, European Patent Databases, and IP India. The next exercise is prior art analysis. For training purposes, our case study provides 6 hypothetical prior art documents. Document 1 relates IoT sensors for warehouse temperature and humidity monitoring. Document 2 relates to RFID based warehouse inventory tracking. Document 3 relates to cloud-based warehouse monitoring dashboard. Document 4 concerns edge computing for industrial sensor data. Document 5 relates to automated warehouse cooling based on environmental conditions. Finally, document 6 describes a system combining RFID information with environmental monitoring. Now, participants should critically analyze each document. Ask 4 important questions. First, what technical features are disclosed? What features are missing? What was the document published before the proposed invention priority date? Sorry, let me reframe the question in another way. Was the document published before the proposed invention's priority date? Does a single document disclose all the elements of the proposed claim? The participant should also consider whether multiple prior art documents would potentially be combined when analyzing the inventive step. We now come to one of the most important practical activities, claim chart. Our proposed independent claim includes an RFID-based inventory identification unit, environmental sensors, edge processing controller, correlation of inventory information with environmental and energy consumption data, and a decision engine that automatically initiates warehouse control operation. Participants must map every element of the proposed claim against the relevant prior art documents as shown in the matrix. Say, for example, document 2 discloses RFID identification, while document 1 discloses environmental sensors. Document 5 discloses automatic control based on environmental condition. But the important question is whether one document discloses the complete combination, particularly the correlation of inventory, environmental, and energy data with an adaptive control mechanism. This leads to a fundamental patentable question. Does one prior art document disclose every element of the proposed claim? If the answer is no, the participants must investigate whether the differences represent a genuine, inventive technical contribution or merely an obvious aggregation of the known technologies. Now, let us convert the technical disclosure into a preliminary patent specification. How to draft the patent disclosure? Suggested title for patent drafting: an IoT-enabled adaptive monitoring and control system for smart warehouses. The field of invention relates to warehouse management system and more particularly to monitoring inventory, environmental parameters, and energy consumption while automatically controlling the warehouse operations. The background section should explain the existing warehouse monitoring technologies, their limitations, problems associated with separate monitoring systems, the need for integrated monitoring and control, and the need for real time decision making. Next, we formulate the objects of the invention. These may include providing an integrated warehouse monitoring system, continuously monitoring inventory and environmental conditions, reducing manual monitoring, improving energy efficiency, generating real time alerts, and enabling the automated con- con- control based on multiple data parameters. Next one is drafting the patent claims. Now we now reach the most critical component of the exercise, claim drafting. Participants should first attempt to prepare a broad independent system client covering the essential technical architecture. After that, the dependent client can be developed around RFID identification, temperature and humidity sensing, energy monitoring, edge-based processing, predictive analysis, automated cooling control, alert generation, cloud dashboards, mobile monitoring, and inventory risk identification. Let us compare two approaches. A weak patent claim might simply state a smart warehouse system using IoT sensors and RFID. Such a claim is very broad and may merely combine known technologies. A stronger technical formulation focuses on the functional relationship between the components. It describes an RFID identification unit, environmental sensing units, and an edge controller configured to correlate inventory specific environmental conditions with energy consumption parameters and automatically initiate selected warehouse control operation based on that correlation. The important lesson is that good patent claims are not necessarily long claims. They stated clearly to identify the essential technical features, their functional relationships, and the technical contribution of the invention. We now evaluate the invention against the major patentability consideration. The first consideration is novelty. Is every element of the proposed claim disclosed in a single prior art reference? Second consideration is inventive step. We ask whether a person skilled in the relevant technical field would have arrived at the claimed combination using the available prior art. The third consideration is industrial applicability. Can the claimed system actually be made or used in an industrial application? Finally, we must consider patentable subject matter and whether the claim defines a technical invention rather than merely an abstract idea or a business concept without sufficient technical contribution. Let us now bring the entire exercise together. The practical workflow begins with technical idea, followed by invention disclosure, then identification of the novel technical features, followed by generation of keywords, database search, identification of relevant prior art, preparation of claim chart, identification of novelty gaps, inventive step analysis, drafting of the independent claim, drafting of the dependent claims, drafting of the description, preparation of drawings or flowchart, review of claims against prior art, and finally patent draft. So this is how we need to convert the priority or search to drafting workflow in step-by-step sequential process. Now, for participants, I'm going to give an hands-on assignment. Now it is time for participants to undertake an actual assignment. Each participant or team will conduct a prior art search and prepare a preliminary pattern claim for an IoT-enabled smart warehouse system integrating RFID inventory identification, environmental sensing, energy monitoring, and automated control. Expected deliverables include invention disclosure, so minimum of 15 search keywords, at least 10 relevant patent documents, the top 5 prior art references, prior art comparison table, claim chart, novelty analysis, inventive step analysis, one independent claim, 5 dependent claims, brief patent description, architecture, one system, architecture diagram, and finally patentability assessment. So this assignment is for the participants who are engaging for day 3, the faculty development program. Students or faculty members, whoever may be, they are free to take up this assignment from your working premises. By referring to the existing patent databases, you can draft your own documents. By completing this exercise, participants should be able to move systematically from an engineering or research idea to a pattern-oriented technical disclosure. They should also be able to conduct a structured prior art search, identify the novelty and inventive step issues, construct a claim chart, and prepare initial set of patent claims. One important point must be remembered: the prior art documents D1 to D6, as mentioned in the case study, are just hypothetical and illustrative. During the live FDP exercise, a participant should replace these hypothetical references with the actual patent documents obtained from appropriate patent databases. The ultimate objective of this hands-on activity is not simply to learn how to write a patent claim. It is to develop the ability to identify the real technical contribution, search the existing technological landscape, distinguish the known futures from novel futures, and draft claims that accurately capture the inventive concept. So we came to the end of the case study. We will resume back to the remaining details as given in the PowerPoint presentation. The module 5 is analyzing the prior art, novelty, and inventive step. We now arrive at the final technical session of day 3, analyzing prior art for novelty and inventive step. Let us first consider the novelty stage. As presented in the program, novelty is associated with section 2, and the invention must not form part of the state of the art. An important point is that a single priority art disclosure can be highly significant. If one prior art document discloses all the features of the claimed invention, the novelty of the claim may be defeated. Therefore, during a novelty analysis, participants should carefully map each claim feature against the relevant priority art disclosure. Next, we consider inventive step. Under section 2 concerns a future involving technical advance, economic significance, or both, which is not obvious to a person skilled in the art. The analysis therefore goes beyond simply asking whether individual features are already known. We must consider whether the claimed combination or modification represents a non-obvious technical contribution. The presentation emphasizes that the claimed solution should not merely be predictable to a skilled practitioner. During hands-on exercise, as I explained just few minutes before, the participants will map their search results onto a novelty inventive step matrix, as already discussed in the case study. and this will help to develop a structured and defensible patentability argument of a sample invention. By the end of today's session, the participants are expected to develop four important practical capabilities. First, the participant should be able to draft a patent specification effectively. Second thing, they should be able to conduct a systematic prior art search. Third, they should be able to analyze the prior art for novelty and inventive step. And fourth one, they should be able to strengthen the patentability of their invention through better drafting and evidence-based prior art analysis. So these skills are valuable not only for academic researchers, but also for faculty members, PhD scholars, students, innovators, entrepreneurs, and industry professionals who are interested in protecting and commercializing intellectual property. As we conclude day 3, I would like to emphasize one important message. A good invention deserves a good patent strategy. A technically excellent invention may not receive effective protection if the specification is poorly drafted or if the relevant prior art has not been properly analyzed. Therefore, patent protection requires a combination of technical understanding, systematic searching, precise drafting, and careful patentability analysis. I encourage all participants to actively practice the techniques discussed today, work with the actual examples, and apply the learning to their own research and innovative ideas. Thank you for your active participation and valuable engagement. Let us continue to learn, innovate, and protect. We will meet in the day 4 faculty development program on intellectual property rights. Thank you all.